My name is Camille Tynes. I'm from Detroit, Michigan, and I'm here to speak on the family court corruption in Detroit, Michigan. When I was 14 years old, I was taken away from my mother on illegitimate causes. I am one of 6, and the Family Court Protection Agency, they didn't protect us at all. In fact, they put us in harm's way. I'm asking you to please take a look at the corruption within the state of Michigan. There's too many families that are being ripped apart, and nothing is stopping these judges, these foster care workers, these people from ripping apart the lives of different people. I was sexually molested by my father and physically abused. On a day-to-day basis, I went without eating. I was physically abused, mentally abused, but yet no one helped us. I and my siblings, we told consistently to our counselors, our workers, everyone, including the judge, both the judges that were on our cases, but yet no one listened. In fact, they turned a deaf ear. This is too big of an issue. When we go through the court systems, we're treated as though we are the criminals, and yet we are truly the victims. We're told that we're lying. We're told that we're either mentally ill, or even when you show them all the evidence that's there, they say, well, then it's in the past, move forward from it. But I'm asking you, I'm pleading with you, save our American families, save our families, and look into this situation.
I had just currently found out that there was another sexual assault currently, just a couple of months ago, with his new 2.5-year-old daughter. And again, he lied and blamed it on another family member instead of them addressing it. Again, it's ignored. He sexually assaulted all 6 of our children. They had shared that with me. As I went forward to try to protect them and to put a stop to it, I was accused of being the one of putting the sexual abuse into my children's heads based on their father's wording. Several of his friends, including the Chief Judge, Virgil Smith, got on our case, and from there, everything was ignored. I was defamed, I was harassed, I was intimidated, I was threatened to back down. They told me to plead no contest for no housing, or I would never see my children again. When I refused to do that, they continued to keep my children from me. When I finally felt pressured and scared of never being able to see my children and stated I plead no contest for no housing, I found out a month later by a psychologist. She gave me a stack of paperwork. She said, this is the paperwork they do not want you to see. I read it, and it stated in there that I pled no contest to being mentally ill. I never did that. That's a flat out lie right there. They failed to report when my children were getting F's and failing in school with their father when Judge Virgil Smith forced the children to be placed back with him, knowing that there was enough evidence. I had found out by Dr. Wanda Huggett, who stated Judge Kim Smith knew she had enough evidence to keep my children from him and did not do it because Judge Virgil Smith, who's now the Chief Judge of Wayne County, told judges, attorneys, therapists, even attorneys at legal aid when I went there not to help me, not to even help me pursue my spousal support. My ex-husband was in the arrears of over $42,000 in child support and owed me spousal support, which was all court ordered, which I never received. It ended up going to the foster care system when they took my children based on falsification and distorted information. And from there, when I went to the FBI, showed them my evidence, they felt there was enough evidence and showed that it was proof of major corruption going on, but they never did do anything. They stated that they didn't handle this part of the case. An FBI agent from another city, Bay City, Michigan, told me she wanted to take my case because Detroit, Michigan, FBI, nor police, nor courts were doing their job in protecting my children. She stated her supervisor told her that I was out of her jurisdiction. Next thing I knew, she was transferred to another state. I found out through the U.S. Attorney's Office.
Welcome to RICO Busters. Today's show presents the 6th in a series of investigative segments focusing on the corruption that had long been infiltrating the Detroit metropolitan area known as Wayne County. In our previous segment, we caught detailed glimpses of how the Trott & Trott law firm, presided over by the aspiring Republican politician David Trott, engaged in fraudulent mortgage, foreclosure, and court transactions, along with his fellow attorneys and banking partners and clients, already popularly known to have committed similar crimes upon the public en masse. In the last segment, we outlined how the policies of the government-sponsored enterprises of Freddie Mac and Fannie Mae violate Title 12 of the Code of Federal Regulations pertaining to mortgage transfer disclosures, which is supported by multiple case law references that have reaffirmed that such practices are unlawful. We saw how Fannie Mae and Freddie Mac policies require assigned nominees like MERS or servicing bankers to foreclose on homes in their own names, using foreclosure agents like the Trott law firm to mislead homeowners and the public into believing that the servicing company holds ownership and possession of the original mortgage and promissory note, when that is actually not the case. A violation of the Truth in Lending Act and a violation of the Fair Debt Collection Practices Act. It's fraud, pure and simple. Yet it is the status quo of how foreclosures are going down in Wayne County and elsewhere throughout the United States. Meanwhile, as shown throughout our previous segments, the Trott law firm has compounded the breadth and the depth of their misrepresentation and fraud. The owner, David Trott, readily admits profiting at each juncture of the foreclosure process and markets his company as a one-stop shop, profiting at every point along the foreclosure process, by his firm having bought up title companies to facilitate the construction of fraudulent foreclosure paperwork, by owning, at least in part, the Detroit Legal News, where fraudulent public advertisements are posted, and by maintaining a staff of partnering attorneys with reputations such as robo-signers, and who appear to regularly engage in fraud upon the public and upon the courts. This one-stop shop setup for crooked, what we might call banksters, mixes with corrupt district, county, and federal judges located throughout Michigan. We're talking about elected members of the judicial and executive branches receiving Trott's campaign payoffs, such as prosecutors, the Michigan governor, and the Michigan Attorney General, who are willing to look the other way, which altogether sets the perfect stage for a racketeering operation of such proportion that it has such potential to produce the kind of devastating economy seen in the Detroit metropolitan area, and by contrast, in the disproportional wealth that has been realized by the Trott law firm since the housing crisis and bank bailouts from around 2008. Many are saying that the entire system of Wayne County government is corrupt, from top to bottom, as is the government of the entire state. Are we, the people, exaggerating about such claims? Stay tuned, and you'll find out, right after this upcoming word from our sponsors and Liberty News highlights. What does liberty mean to you?
The price of freedom is eternal vigilance.
Does it mean being able to vote as a Democrat or a Republican? The National Liberty Alliance emphasizes the exercise of your individual rights under common law. Check it out. NationalLibertyAlliance.org.
I'm Congressman Alan Grayson, and I represent Central Florida, an area hard hit by the foreclosure fraud crisis. Foreclosure fraud can affect anyone, whether you have a mortgage, are paying on time, have income, or not. The average foreclosure hearing in a Florida court is only 90 seconds. Mistakes are common, and fraud is rampant. Everyone is familiar with dealing with a big bureaucratic institution. What is happening is that these big bureaucratic loan servicers are charging fees inappropriately, refusing to talk to homeowners by putting their calls through to call centers in India, and then foreclosing with forged documents once the homeowner has been drained of all assets and even the will to fight. There's one set of rules for the banks and another set of laws for everyone else. A servicer can ask for fees, it can demand payment, it can send you to one of those call centers in India, and it doesn't have to negotiate. And you now have virtually no rights as a homeowner. Here are 4 bizarre examples. First, last summer, Fort Lauderdale resident Jason Grudensky experienced what has tragically become an increasingly familiar process all across America. His house was sold at a foreclosure sale after a bank notified the Florida courts that Grudensky had defaulted on his mortgage. The foreclosure came as a surprise to Grudensky, according to reports from the Sun Sentinel. Not only did Grudensky not have a mortgage with the bank that sued to foreclose against his house, he never had a mortgage at all. Grudensky had paid cash for his home. Second, one house in Pinellas County, Florida, saw 2 mortgage foreclosure suits brought against it because the banks didn't know who had title to the mortgage. Third, one victim with a perfect payment record of all interest and principal was foreclosed on because of a $75 contested late fee. And fourth, Tim and Nicole West were victims of a predatory loan. In 2005, a bank threatened to sue the couple if they didn't sign a refinancing offer. Their loan servicer has subsequently raised their payments from $1,900 a month to $5,300 a month, with regular forbearance fees required in the tens of thousands of dollars. Finally, the servicer refused to accept payments from the family in the name of negotiating for a mortgage modification. But instead of modifying the loan, their servicer began foreclosure proceedings. The servicer used fraudulent documents to prove that it had the right to foreclose. Here's how it all happened. Securitizing mortgages was originally a way to take the cost of the mortgage off of a bank's books. From 2005 onward, the securitization chain went out of control, and Wall Street wanted as many mortgages as it could get as quickly as possible and as cheaply as possible. In order to allow it to pull out more fees at every link in the chain, these subprime lenders, trusts, and banks decided to cut as many costs as possible, including the cost of record keeping. They didn't keep good records, and they violated the laws mandating that they had to file records with the county clerk on who owned what mortgage title. Instead, the banks simply digitized mortgage titles into a privatized system called the Mortgage Electronic Registry System, or MERS. And it did the transfers by trading Excel spreadsheets among the banks and trusts, rather than endorsing the notes as required by their own contracts, by state real estate law, and by IRS rules. Today, MERS is the registered owner of a security interest in 60 million properties, or about 60% of the mortgages in the United States. In fact, 97% of the loans originated between 2005 and 2008 are in the MERS system. It appears that on a widespread and probably pervasive basis, they did not take the steps necessary to own the note, a borrower IOU, which means that in 45 out of the 50 states, they lack the legal right to foreclose. Thus, every trust now has questionable legal standing in foreclosures in the overwhelming majority of states. In addition, their records were poorly kept, so servicers are basically guessing that they have the right to foreclose when they do foreclose. Obviously, the banks do not want to grapple with the consequences of trillions of dollars of securitized mortgages having no legal standing to foreclose. So they have simply created a system where servicers hire foreclosure mill law firms, whose business is to forge documents showing or purporting to show that they have a legal right to foreclose. Some of these foreclosure mills have been featured in the New York Times, and so-called robo-signers, people whose names appear on thousands of affidavits. These appear despite obvious forgeries and overt omissions, and in cases where these people admit that they had no knowledge of what they were signing. The system is so organized that there is a company called Lender Processing Services which allegedly has created the means to systematize this fraud. Lawyers use the LPS system to request which affidavits and documents they need. LPS then has document mills, where they can magically make an authorized vice president of whoever you need and send you backdated signed documents saying that you have the right to foreclose. Courts at first refused to believe this level of rampant fraud even exists. But more recently, they've started to sanction fraud against loan servicers. Here are some examples of signature forgeries used on documents filed with the courts. These are 4 clearly forged signatures of Document Mill employee Linda Green. Here are 6 signatures of Christina Wang. And here are 3 obvious forgeries of Taiwana Thomas. Finally, this is a mortgage assignment filed with the Recorder's Office, in which the foreclosing firm forgot to put the name of the assignee. So they instead put bogus assignee. The filing firm simply forgot to change the template for whose home, which family's home, they wanted to take. This is a factory of fraud. Servicers don't make money through routine servicing. It's a break-even business. They make their money on foreclosures at $6,000 for each foreclosure through their fee. When you combine the incentive to foreclose with systemized fraud, it's rampant lawlessness. Fraud is now a big business, and sanctioned in part through the government, as both Fannie Mae and Freddie Mac are shareholders in MERS. We are approaching the point where the easiest way to make a buck is to steal it. The only way to end this plague of foreclosure fraud is to make sure that crime does not pay. I'm Congressman Alan Grayson. Thank you.
So how do we, the people, ensure that crime does not pay when the self-regulating of the corporate government oligarchy reflects rampant corruption? When the self-policing and the self-reporting smells of a massive cover-up of crimes? And when at least 2 of the 3 branches of government are involved in racketeering schemes of collusion rather than constitutional checks and balances? We, as investigative journalists, have been asking ourselves these and other important questions, such as how David Trott and the Trott & Trott Law Firm, the Wayne County Sheriff's Department, Register of Deeds Office and Prosecutor's Office, and local, state, and federal judges can continually get away with fraudulent foreclosures, fraudulent property deeds, fraudulent judicial orders and judgments, and prosecutorial misconduct. To answer these questions, we analyze the available documentation and follow the money trail. For instance, in answering why David Trott and his partners in crime remain free to continually make millions of massive numbers of property foreclosures using misleading advertising and fraudulent sheriff deeds, by using robo-signers instead of legitimate notary publics, and by using illegal procedures under mere color of law, and why these criminals are not yet in jail, one might not need to look much further than the fact that for a number of years David Trott's wife, Kathleen, has been employed by the last 2 administrations of the Michigan Attorney General. In fact, all the further one need look is at another fact that Trott, his wife, and several Trott & Trott attorneys committing crimes against Crystal Price and so many others are giving directly to the political campaigning of Michigan's chief law enforcement officers and the Michigan governors. Here are some examples of donations to Attorney General Bill Schuette by David Trott and others we have spotlighted under employ at his Trott Law Firm. Here is evidence that Trott's wife, Kathleen, has been and continues to be employed by the Office of the Michigan Attorney General, Bill Schuette. It is obvious that this Trott family has long been using their political and financial clout to buy favoritism and the incentive for Schuette to abandon his oath and his duty of office to arrest and prosecute someone like Trott, who is so closely related to his own office. This is the dereliction of Schuette's obligation to we the people of this state, and it is clear that such malfeasance of office has greatly cost us stakeholders in constitutionally guaranteed freedom, who treasure the simple pursuit of happiness and who are willing to die to protect our constitutionally guaranteed property rights. We are talking about racketeering and corruption, plain and simple. Let's take a close look at what we know thus far about the so-called players or actors in Crystal Price's case, who are those harassing, terrorizing, and stealing from this law-abiding and God-honoring homeowner. While we present an overview of what she has been enduring this past nearly 5 years, we will also illustrate more of what Congressman Alan Grayson was talking about is happening all over the country with foreclosure fraud, starting at the top. It appears that the U.S. Department of Justice's Office of the Inspector General concurs with Congressman Grayson, and I expect millions of other Americans, in that not enough is being done to hold white-collar criminals, like the racketeers we have been spotlighting in Wayne County, accountable for their foreclosure fraud schemes, which are closely associated with mortgage fraud. According to a March 2014 audit of the Department of Justice efforts to address mortgage fraud, the Financial Fraud Enforcement Task Force reported that tightening lending practices following the collapse of the housing market in 2008 has caused mortgage fraud crimes to evolve away from loan origination fraud towards foreclosure rescue and loan modification scams and short sale frauds. Short sales are typically where the proceeds from selling the property are expected to fall short of the balance of debt secured by liens against the property. So the lien holders agree to release their lien on the real estate by the sale of the property for a lesser amount than is owed on the debt. This was the type of shenanigan that former Michigan Supreme Court Justice Diane Hathaway was convicted of before being sent to a federal prison in 2013 for bank fraud. The audience should note that this Judge Hathaway was employed for an entire decade in the corrupted Wayne County Circuit Court, a central focus of our investigation into racketeering as it encompasses the Wayne County Sheriff, the Wayne County Register of Deeds, the Wayne County Prosecutor, the Wayne County Executive and his Corporation Council, and numerous of local district courts in neighboring towns, such as the 17th District Court in Redford Township and the 34th District Court in Romulus. The objective of this Inspector General's audit was to assess the U.S. Department of Justice's approach and enforcement efforts in addressing mortgage fraud. Not surprisingly, the report found underreporting of many white-collar financial crimes by the U.S. attorneys across the country, and dereliction of their duties as federal prosecutors. RICO Busters has loads of evidence against the U.S. Attorney Barbara McQuaid and her so-called assistants employed in the federal region of the Eastern District of Michigan. We will expose McQuaid's part in the grand scheme of this statewide racketeering operation in a later episode of RICO Busters. In short, the audit also found serious flaws in the Department of Justice's statistics, and that despite knowing about these inaccuracies, the U.S. DOJ continued to intentionally misrepresent and overestimate their prosecutorial performance when addressing the public through press releases and other announcements. The fact of the matter is, the conspiracy to cover up government and corporate wrongdoings by federal prosecutors across the country is as bad as these underlying crimes to which these U.S. attorneys turn a blind eye. What the Inspector General's audit uncovered was part of the problem, was that despite being allocated certain increased funding to address these types of financial crimes, the number of mortgage and foreclosure fraud cases opened by the FBI for investigation actually declined because of a substantial diversion of resources for going after these white-collar criminals. One might bet that these resources of the FBI were put to more use investigating so-called sovereign citizens and Ron Paul supporters, leaving the door wide open for people like David Trott and his elitist group to continue ransacking the rest of the people of the state. In fact, some of that budget was surely being used to pay for the FBI's unexpected visit to my home in February of this year, while searching for Americans who knew their history well enough to consider themselves as sovereign men and women, while also asking whether I knew people engaging in mortgage discharging schemes or exercising their right to travel without first asking permission from the government to utilize roads and highways already paid for by their hard-earned taxes. I was thus compelled to inform the FBI agent who came to my door, whose name was Brand, that he was looking for the wrong individuals who considered themselves the so-called sovereigns. The ones I told him he needed to seek out were the ones in the black robes, pretending to represent the sovereignty of the government and the courts, who are all members of the very same state bar of Michigan, who can be found passing through the ever-spinning revolving door between the executive and judicial branches of government, and who are persistently awarding governmental immunity to one another for participating in their criminal enterprise. What got to me when reading the results of this Inspector General's audit investigation and report was the discovery that 747 mortgage fraud cases were closed with little or no investigation whatsoever, to supposedly put more focus on cases with multiple victims, higher dollar losses, higher fraud activity, and organized racketeering groups. With the high level of government and citizen criticism about David Trott being the foreclosure king, about his Trott and Trott business partners being engaged in robo-signing, with the notoriety received by class action and other court cases pointing to fraudulent activity involving notaries and special sheriff deputies appointed by the former and current sheriffs of Wayne County, Warren Evans and Benny Napoleon, and the like, might I dare ask, why should it take the FBI so long to act upon the proverbial writing on the wall, figuratively speaking, of those holding the political power in Michigan? If it is not an issue of sovereign immunity, or if it is not a dereliction of duty and criminal malfeasance to continually reject the idea of arresting these white-collar lawyers, these black-robed judges, and those both above and below them serving to aid and abet these quasi-government and administrative agencies.
Let's go back to them filing a summons and complaint.
Okay.
Who filed the summons and complaint on whose behalf?
Freddie Mac filed the complaint.
Okay.
Okay.
Through their attorneys?
Through their attorneys, Trott and Trott.
Trott and Trott. So now Trott and Trott has gone from representing Bank of America with all these notices on Bank of America's behalf.
That's right.
To now they're representing Freddie Mac.
Right.
Okay.
So.
And they file a suit against you to evict you.
To evict me, right.
Okay.
So when they filed this suit to evict me, I always say, when you're in court, what makes up jurisdiction is subject matter jurisdiction, which is a thing, and personal jurisdiction, which is a person, an injury, whatever, okay? But it has to, these two things have to exist in order to have jurisdiction. You must have a plaintiff and a defendant, two opposing people with two different opposing interests to have a dispute.
Somebody's been damaged, somebody did the damage.
That's right.
Right.
So when we go into court, these attorneys show up representing Freddie Mac, Fannie Mae, the bank, and everybody else. But see, that's wrong, because there's supposed to be a client there. An attorney cannot, briefs or oral arguments are not facts before the court. That's
because the lawyer can't testify.
That's right.
And you can't question and cross-examine a lawyer.
That's right.
Just because he's on the other side.
That's right. And so they've been getting away with this so long. They've been taking, when pro se's go into court and they challenge, well, where's the injured party? Oh, we don't have to do that. Oh, yes, you are. Because I have a right. See, that's my due process there. You're denying me my rights. I have the right to stand before somebody who says I owe them something. I have a right to cross-examine them. I'm not cross-examining no imaginary person. And I'm tired of talking to Freddie Mac, a building, because that's exactly what you're talking to, a building. Okay, I want to see a living, live human being in here. So,
even though under codes and all this stuff, they have determined that corporations are persons.
But they're not, and I can prove that.
And
they're
they
not.
have no heart.
That's right.
They have no feeling.
Why do you think they had to? Why do you think MERS is no longer considered a lender? Because it's a machine. You can't talk to it.
No accountability.
You have to, right, no accountability. So that's why MERS no longer is a part of this. They've determined that MERS it can't talk to you. People put the information in, but he can't spit the information out unless you put it in, right? So it's not a person. Same thing with Freddie Mac. He's just a building. Okay, I want a representative. So when the claim was filed, I'm thinking I'm going to court and I'm going to be facing Freddie Mac. Well, here I'm facing an attorney, okay? But before we even get to court, somebody has to bring the claim, the petition. So who's bringing the claim in the petition if Freddie Mac is the building, right? Who's bringing this claim against me? Somebody's got to procure the oath to bring this claim or a petition, right? So I'm wondering who's bringing it. This is in my file. They have filed this, Trott and Trott, on Trott and Trott's letterhead, and it's February the 6th, 2012, to the 34th District Court, Romulus, Michigan. In Prince, last name.
Good old Freddie Prince again.
And it says,
He must have risen from the dead, I think.
the wrong last name, Dear Civil Division, please find a complaint and summons for filing and a check for the filing fee of $45 and a check for the service fee of $48. Please be advised that the hearing has been preset for February 23rd at 2012 at 9:30. So you're reading this and you're thinking, okay, this got to be the person who's the plaintiff. Along with the address referenced above, please serve notice of these proceedings on any and all additional addresses and units which may be encompassed within the dwelling. Okay, so I'm reading it. Then it goes on to say, please have A. Heidman and N. Jones serve the complaint and summons on defendants. Thank you for your assistance. Yours very, very truly, Trott and Trott, Eviction Court Team. A. Heidman, or Hidman, is the court administrator. Since when does the court administrator serve a defendant summons and complaint? That's not his job.
This Hindman is the court administrator for which court?
34th District Court.
34th District Court. Okay. Is
So-
he still?
Yes, he is.
Okay.
So Trott and Trott is using the court administrator to set up the delivery of the summons and complaint. You understand what I'm saying?
The court administrator, isn't that a taxpaid?
That's right.
How can a law firm use the taxpayers' money
That's
just
right.
to have something served?
That's right.
Okay.
So where's the person? So see, there again, this is Trott and Trott's mess. Okay? He's getting the court administrator to serve the notices of complaint and summons on the defendants. Can't be.
Being Freddie Prinze Jr.
Freddie Prinze Jr.
That's his son, I guess.
Can't be. This is fraud. There has to, in order for a complaint to be filed, the person that's making the complaint, the petition, has to have their name. There's no name of who the plaintiff is. It's just telling the civil division to do a summons and complaint.
And what's interesting is that nobody even bothers to sign it. And so we have no accountability.
No.
There's nobody that's held accountable, you know, which is why we are holding David Trott. He's running for office.
That's right.
Yeah, here in Oakland County, Michigan.
That's
you know,
right.
he is the name above this, all of this stuff here.
That's right.
So, you know, let's have David Trott answer to some of this stuff. We invite you.
So now they're serving the summons and complaint now in Prince. So now we're going into the court
Okay.
under the name Prince.
Okay. You're up against Freddie Mac now.
I'm up against Freddie Mac
Okay.
under the last name Prince.
You and the government.
Me and the government.
All right.
But the only thing is, your very first court appearance is your summary proceedings. That's where you get to go in front of the judge and say if you want a jury or not. You get to go in front of the judge to plead. Are you guilty or innocent? Do you owe anything? The dispute. They brought this charge against you. You have a right to defend yourself.
Okay.
I didn't have that right. I never went in. I never had a summary proceeding. I never got a chance to say I want a jury. Can I get a lawyer? What's the charge? What did I do wrong? What am I in default for? How much? Nothing.
This was filed in what year?
2012.
2012. So, and here we are in 2014, and it's only this year that you finally got in front of a judge
March the 3rd.
for the first time.
For the first time.
2 years.
2 years.
And in the meantime, they are tearing you to shreds, trying to evict you. You're doing what you're supposed to be doing. What I want to do is cover what you did through your attorney, what your attorney did to you. in an effort to try to extort money out of you and be part of this racketeering operation. So he's pocketing some money. And you were able to, through your investigative skills and prowess and caring about your home and your family, that you were able to document these underhanded schemes that everybody is doing here. And it's really amazing. And we'll need to move through these documents as fast as we can.
So obviously the reason why I didn't have a summary proceeding, because they knew they foreclosed in the wrong last name. So they were trying to get rid of me at the beginning, but they couldn't shake me. They tried, okay? And so...
Through trickery.
Through trickery, that's right. And so what they did was they went ahead and did a ex parte hearing.
Ex parte meaning that you have no representation in this discussion. It's just something that's being done behind closed doors between the other party.
That's right.
And the judiciary. In this case, the judge's name was?
Judge Oakley, Brian Oakley.
Brian Oakley.
That's right.
Okay.
And so what they did was they ex parte their so-called summary proceeding. See? And they made it like we were in a hearing. They documented as, you know, on the front of your paper it says in a hearing at a session and the date and all that. Well, they doctored it all up and did it on the paperwork. And they put me into a stipulated order to pay $700 a month starting April 1st of 2012. And the only two people that signed the document was the judge and the plaintiff's attorney.
The plaintiff being Trott and Trott.
Trott and Trott, that's right.
Trott and Trott and the judge.
That's right. And
sitting
where
in
my
a tree.
That's right. And where my lawyer's name was, his signature line said "see attached" written on it, and there was no signature line for me, or my name wasn't even on. There was no meeting of the minds. They put me in the stipulated order. The only reason why I abide by the stipulated order is because he threatened me. He said if I didn't,
he who?
My lawyer. He told me he threatened and intimidated me. He said if I did not pay the stipulated order, I would lose my house or lose my case.
And your lawyer's name was?
Henry Sandweiss.
Sandweiss.
Yes.
Is that right? Okay.
Yes. So of course, being frantic, you go and pay. And when I went down there to go pay it, because it was due on the 1st, and he called me on the phone, it was Easter time. So Good Friday they were closed, Monday they were closed, you know, Easter. So when I finally got down there, it was the 10th. When I go in there, I asked the clerk, where's the papers for me to sign? Oh, there is no papers. I'm like looking at her like, what do you mean there's no papers? There's no papers. Your lawyer didn't give you the order? I said no. So, of course, not knowing, I give her the money. And I start making my payments. But in the meantime, I'm still trying to contact my lawyer to get some paperwork.
In other words, you're keeping if there's any doubt of anything, here is my good faith. Just you know, I just want to make sure I keep my home.
That's right.
I can see your point.
That's right. 2 years, $700 a month. Faithfully.
You
had
paid?
to be there on the 1st of the month. And then they gave me a 7 days grace. How generous of them.
Didn't you find out that there was no hearing?
Right, there is. Yes, here's the document
You
right
have
here.
some?
Yes, here's the document right here.
Even though there's some document that says there was a hearing held.
Yes, the order, the stipulated escrow order says that there was a hearing on March the 27th of 2012 regarding a stipulated escrow order.
Okay, we've got that in the graphic, okay?
Now, 34th District Court reporter, I'm now requesting the transcripts
With that hearing.
of that hearing.
There was a hearing. There was a hearing.
That's right.
Give it to me.
Give it to me. So this is dated April the 8th, and of course she messed up the date, requested transcripts for March the 28th, so I had to have her. I said, where'd you get the 28th from? She said, oh, it was the 28th. I said, no, the 28th is when I said, you know, she's...
You can't even get something right when you're asking for something because they're all in part of this cover-up here.
Because I said, as per our conversation on March the 28th, she thought that, I said, no, see, it's the 27th is what I was requesting. So I had to get her to rewrite it. So she finally rewrote it on the 25th of April. And it says, go ahead, read it.
I have rechecked my record for the amended listed date, which is the March 27th and April 3rd, and you did April 3rd because there's something else occurred. We haven't got to that yet. The date of March 28th was addressed in error. I have found no record for the case you have requested transcripts for, being March 27th of 2012, that stipulated order. Period.
That's right. Paula Moore, court recorder, judicial assistance for the Honorable
Brian
A.
Oakley. Okay, so did it happen or didn't happen? Well, it did happen behind closed doors.
That's right.
With Trott and Trott and the judge, and little under the table stuff, right?
That's right. That's right. So
this is the way our judicial system is operating. Let's take a quick break because I feel my blood pressure going higher.